How do you beat a theft charge in Texas? This may be somewhat surprising, but many theft cases are filed that have nothing to do with an underlying need for the items that were taken. For example, people shoplift for the thrill of it. Teenagers take things because they haven't been caught before and they think they're going to get away with it one more time. A surprising demographic that we often work with are middle-aged women. These are sometimes women whose kids are now old enough to be off at school or even empty nesters. They generally have no criminal history, and yet they're driven by a compulsion, sometimes full-blown kleptomania, but this desire to do something that is risky. It's almost thrill-seeking behavior, and it comes up more commonly than you would expect. Many of our clients who are charged with theft, like these women, have never been in any sort of trouble. They have clean criminal records. And the problem with being alleged to have committed theft is that it is a crime of moral turpitude. If you're convicted for or plead guilty to a crime of moral turpitude, that can be used against you. It basically labels you as a dishonest person. So anytime we're working with our clients who are charged with theft, our goals are more than just keeping them out of jail or avoiding the conviction. We also want to do everything humanly possible to get even the arrest record sealed, or even better yet, destroyed. That would be through the non-disclosure or the expunction process. But for example, to get a case expunged, you have to resolve the case in the right way. For expunctions, that generally means the offense was reduced to a Class C misdemeanor or a ticket and deferred, the case was outright dismissed, or you went to trial and you were found not guilty. Obviously, for risk-reward reasons, that third category is not one that you want to fall into. So the name of the game when you're charged with theft is, how do you convince a prosecutor ideally to flat out dismiss your case? We generally adopt a 1-2 approach when it comes to battling theft cases. The first part of that equation is looking for weaknesses in the case. That's something that we as attorneys do. The second part of that equation is mitigation. Those are the things that we put together as your attorneys to show who you are, but it also includes things that we will ask you to do that separates you from everyone else who is charged with a similar offense. As to finding weaknesses in the case, you have to understand many shoplifting cases have very good evidence against you. For example, folks that work at Target in the loss prevention department are often given the same training when it comes to in-store video surveillance that FBI agents are given at Quantico, which is surprising to some, but when you understand the millions of dollars that are at stake for a company like Target, you'll understand why they put so much effort and money behind trying to capture evidence of something like a theft. Another factor that often cuts against you in theft cases is the case law in Texas. Unfortunately, the appellate courts in Texas generated some really bad case law. For example, you might think that a theft occurs once you've passed all the points of sale in a store. Yet there are cases in Texas that went up on appeal that have established if you take an item and you conceal it even before you leave the store or pass all the points of sale, can be used in a prosecution against you as evidence that you actually committed theft, that you deprived the true owner of their property. That's hard to get your mind around. It's hard for me to get my mind around that even being the case law, but that's the case law in Texas. So you're dealing with bad case law. You're sometimes dealing with really strong evidence from the state. Nonetheless, we're looking for weaknesses in the case. How many times have you put something in your shopping cart, perhaps at the bottom of your shopping cart, and just forgotten about it? Part of what the state has to prove is the intent element. So we focus on anything that we can find that would put even a dent in the strength of the state's case. We then couple that with the mitigation I talked about. That might be you attending a theft class. It might be you attending counseling if you believe you have a compulsion that needs to be addressed, or if I think it's going to make an effect on the prosecutor. It might be doing community service. It might be doing volunteer work. It might be putting together an apology letter. There are a lot of things that can be done. There's a lot of outside the box thinking that we can do to, again, show the prosecutor you should not be defined by this moment in your life. Whether you just became an adult, so you're 17 and you've committed an offense, you don't want that to define the rest of your life. And if you're 55 years old and thinking about going into retirement, you don't want your grandkids thinking about, my grandpa or grandmother was a person who was convicted of a theft offense. It doesn't matter what stage of life you're at. This need to protect your record, to avoid the conviction, and ultimately get the arrest record sealed or expunged is extremely important in theft cases, which is why, again, our goals on these cases are avoid time in custody, avoid the conviction, and protect your record. If you've been charged in North Texas for a theft offense, give us a call. We can help. Thanks for watching this video. If this content was helpful for you, be sure to like, subscribe, and hit that notification icon. You can also find us online at versestexas.com.